You've helped us get to the Supreme Court not once but twice on a key election law issue. We've won one of the cases already. Next one comes up next month, and then the court will decide, presumably by the end of the term, and probably by the end of June or so. The Supreme Court of the United States, there is an argument set in a key Judicial Watch case, indeed an historic Judicial Watch case, concerning elections and whether late ballots can be counted. The hearing has been set for March 23rd. Judicial Watch is taking the lead in challenging states that count ballots that arrive after Election Day. Federal law sets Election Day. It's pretty simple. And if your ballot gets late, it's too late to be counted. But some states count late ballots or ballots that arrive late as long as 2 weeks after Election Day. In Illinois, where we've challenged that law, in California, it's 7 days, and in Mississippi, it's 5 days after Election Day. And there in Mississippi, the Fifth Circuit Court of Appeals ruled that a lower court dismissal of our challenge, and the RNC is also challenging it, we're representing, our lawyers are the Libertarian Party, that the court throwing out the case was wrong, that it is unlawful to count ballots. It contradicts federal law that sets an election day. So it's unlawful to count ballots that arrive after Election Day. It's a pretty straightforward application of the law. Otherwise, it's meaningless. If it's not, if you can count for 2 weeks after Election Day, why not 4 weeks after Election Day? Why not a year after Election Day? Why not up until the next election, for all we know? So certainly elections have to be meaningful, need to have deadlines, and that's the case before the Supreme Court. Now, upwards of 30 states allow the late counting of ballots. The ballots that come in late are counted. So this is a substantial issue before the court, and so the substantial issue is about whether we're going to have elections that A, comply with federal law, but B, have rules that don't invite fraud, because obviously if you kind of allow the ballots to come in after the fact, that's one way and an easy way to try to game the outcome. And we want rules that inspire confidence in the election administration. Because if people think the system's rigged, and yeah, when you count ballots late, or late ballots, as if the Election Day doesn't matter, it makes it seem like the whole thing is a joke. So this is a tremendous case. We're prepping, and part of the prepping obviously is a lawsuit, and that was filed a few years ago, and now it's before the Supreme Court of the United States. And just last month, we had a lawsuit first again in Illinois, but they found, the lower courts did, that our client, Congressman Boss, and 2 electors didn't have standing to challenge the counting illegally of ballots. And the Supreme Court affirmed in a 7-2 decision, thanks to your heavy lifting Judicial Watch, just in January, that essentially candidates have almost an inherent right to be able to challenge unlawful counting of ballots, or as alleged. So that was a major victory and, frankly, vindication for President Trump, who was barred at the court door by ridiculous variations of standing, where all of a sudden a candidate somehow didn't have an interest in making sure an election was run legally, and they didn't have the right to be in court. So that was a tremendous victory. So now this case now is the underlying issue about whether federal law, which sets Election Day, bars the counting of ballots that arrive too late after Election Day, obviously mail-in ballots. So we filed this big brief. It's a big brief. I encourage you to read it. It's available below. How many pages is it? I jokingly complained to the lawyers it was too long to read, but it really wasn't too long to read. It's 48 pages. And I encourage you to read it all. And I'm not going to read you all 48 pages. I'm going to read you a few paragraphs here and there, certainly from the beginning, that give you a feel for what the issue is, because I think it's an interesting issue. You may not agree with me on the issue, but certainly the debate is well worth having. It is about the election administration of our under law since the beginning of our country. It's about who has the right to run elections and under what rubric they do so, meaning what are the states' powers to run elections and how do they intersect with the federal Constitution in terms of federal elections and whether the feds can come in and make sure that the rules are followed in a uniform way. So it's an interesting historic case that gets to the heart of how we elect our politicians into the presidency and into Congress. So if you go and look at there are a few things I wanted to draw your attention to. Let me give you some of the key parts that I think is interesting from the beginning that gives you a feel for what the case is about and helps you understand just how deep the history is as it relates to the law that we're trying to uphold. This case, and this comes from the introduction of our brief, this case is about whether federal elections end on the statutorily designated election day, or whether the receipt of ballots can continue for days or weeks later. When Congress enacted the Election Day statutes, and there are three of them, there was the Election Day statute with respect to the President, Congress, the House specifically, and then once they had direct popular elections for senators, they added the senators to the Election Day statutes. It did so so when Congress set those statutes, it did so to set a uniform day of national elections and to prevent real or perceived fraud occasioned by states setting election day at disparate times. The Fifth Circuit, which is, of course, that's the circuit that made that key ruling that we're trying to uphold, drawing on ordinary meaning, historical practice, and this court's decision in Foster versus Love, correctly held that the day for the election of federal office holders in 2 U.S.C. sections 1 and 7 and 3 U.S.C. section 1, you can go look them up, encompasses both the submission and receipt of ballots such that both must conclude on election day. Because Mississippi, and as I say, many other states, extends ballot receipt beyond the federally fixed election day, its law conflicts with and is thus preempted by the federal election day statutes. The Fifth Circuit's common sense judgment should be affirmed. The conclusion that an election includes both ballot submission and receipt, and not just the former, meaning dropping your ballot in the mail, that's the election? Obviously it's not. Finds support from all the usual sources of ordinary meaning. Dictionaries and treatises from around the time of enactment defined an election to include ballot receipt. State courts did too. Contemporaneous state election codes viewed an election as encompassing both the elector's offer to vote through presentment of a marked ballot and the official's acceptance of that vote through receiving the marked ballot into official custody. The nation's first foray into absentee voting during the Civil War confirms as much, as virtually every state required ballots to be received by the election officials on or before Election Day. There is thus overwhelming evidence that the ordinary public meaning of election at the time the Election Day statutes were enacted encompassed ballot receipt. That view likewise corresponds with the dominant theme and purpose of the statutes, namely that there be a single uniform day by which all the ballots are in and the counting can begin. Arguing to the contrary, petitioner, which is the state of Mississippi, and respondents, Vet Voice Foundation and Mississippi Alliance for Retired Persons, two left-wing groups, advance an entirely implausible understanding of an election. They define an election to include marking and submitting a ballot, but to exclude official receipt of that ballot. That counterintuitive distinction would have struck the 19th century public as bizarre, At the same time, virtually all ballots were marked, submitted, received, and deposited at polling stations in a matter of moments. Nobody from the relevant era would have thought that an election was over before the ballots were received by election officials. After all, receipt into official custody was the very act that transformed an elector's ballot from an ordinary piece of paper into a legally operative vote. To them, the election would have not been over until the ballot box was closed and no further ballots could be received. And we go on to say the whole point of the federal election day statutes is to set a single uniform day for the election. Allowing ballots to trickle in for days or weeks after Election Day is antithetical to that basic goal. Indeed, a patchwork of state ballot receipt deadlines replicates the problems Congress was trying to remedy with a single national election day back in the 19th century. It is entirely implausible to conclude that Congress, when thrice exercising its preemptive power under the Elections and Electors Clauses, left the door open for states to vitiate those statutes by postponing electoral outcomes with post-election ballot receipt deadlines. Congress certainly did not leave the states the power to undo the important federal time regulation by simply declaring all mailboxes to be ballot boxes. Isn't that a great insight by our legal team? Mail-in balloting, they at least argued here, the petitioners are arguing, those defending late counting of ballots, they're pretending that putting your ballot in the mailbox is the equivalent of putting it in a ballot box. Well, that's not only absurd thinking, it's wrong to tell voters that, in my view. Wrong to tell voters that. Because your ballot, as we note, isn't really anything of note until it's captured and counted. Allowing ballots to be received by election officials well after the polls closed on Election Day would have struck the Congresses that passed those statutes and the public that first read them as unthinkable. In short, text, history, and common sense all converge on a single result. The election ends on Election Day, not days or weeks later when the last ballots are received. So it's a pretty powerful case, don't you agree? And I encourage you to read Judicial Watch's brief in this case because it explains and goes back through the history of election laws, not only here in the United States, but in the various states. And there's a particular section I wanted you to take a look at. Great material on how mail-in balloting began and quickly ended, because it began during the Civil War in large measure, and then almost quickly, as soon as the war ended, largely ended. And mail-in balloting in any meaningful measure didn't really start until relatively recently in American history. And certainly the counting of late ballots didn't start in any meaningful way until just 15 years ago, not even that long ago. So this is a significant issue of history that we're trying to put before the court to affirm the long-standing federal law that Election Day is the first Tuesday, the first Tuesday after the first Monday of the month of November. And if you go to page, let me get the brief up for you to show you, because if you're a lawyer, you might appreciate this. I'm not a lawyer, but I do appreciate it because I know what the lawyers have to do for a brief like this. This is the section. Let's take a look at the section. The text of the Election Day statutes confirms the ballot receipt is part of the election. And we go on to describe it. That much is clear later on, we write, that much is clear from the historical backdrop against which Congress enacted the Election Day statutes. State election codes at the time uniformly treated an election as an event to be held or conducted. And so we have the footnote there. You see the little footnote 2? There you go. And then look at the site. If you want to know what your state did, you can look at footnote 2. Look at that. Illinois, Virginia's code. Alaska, is that Alabama? I'm assuming that's Alabama's code. Alabama's code. California, Minnesota, Michigan. There, it goes on and on. Nebraska, Tennessee. So what's great about these footnotes, and I encourage you to read the brief for the full. Here's another footnote with citation after citation of code. And we just don't, at least I hope we don't, I'm sure we don't, use ChatGPT to put these codes in there. This is the result of legal expertise and research, that has no parallel, frankly, in how careful one has to be in terms of making sure every site is correct. But you can go back and look at you can go through and look at all of these statutes, and you can find out what your state used to do back in the day before federal law required states to have a 1 day only, or in terms of a deadline for ballot receipt. So it's just great work by our legal team, which is Legion in this regard. So it's just great work. And I encourage you to go and read the full brief. And as I note in our press release, this is the most important Supreme Court election integrity case in a generation. The pandemic spread of states counting late ballots received after Election Day is a flagrant violation of long-standing federal law that not only encourages voter fraud, but also severely undermines public confidence in our elections. The Supreme Court now has a critical opportunity to restore a fundamental guardrail to the election process. And as I said, a lot of hard work goes into this type of litigation, which is now before the highest court in the land, the most important court in the world, it can be argued. And I encourage you to support our good work in that regard and give credit where credit is due to the legal team that helped put this together. So our election law team is led by Bob Popper, a senior attorney here. He previously was a senior official in the Justice Department, tasked with running voting rights investigations across the country. Also, one of the lead lawyers in this case, who's been shepherding this in other cases, not only in Illinois, Mississippi, but in California, is Russ Nobile, who also served in the public over at the Justice Department, trying to enforce the rule of law on voting issues. And one of our other lead lawyers on these cases is Eric Lee, who is focusing and key to so many of our election law cases, not only this case, but our cases to clean up voting rolls and such. And he's an essential member of the team. And on the outside, we have Paul Clement, who's been helping us in this case and might argue the case before the Supreme Court in March, and James Z, XI, and Philip Hammersley of his firm, Clement and Murphy. So thank you guys for your fine work on this brief. So we've got a lot of great legal talent behind this. And as you know, litigation ain't free. We're representing the Libertarian Party here, and we're really appreciative that they chose Judicial Watch to push this case for them. And on these very issues, we're also representing Darrell Issa, Congressman from California, and Congressman Bost in the famous Bost case that we just won on standing in Illinois. But this doesn't come cheap. The work is significant. It is historic in nature. And in addition to thanking our legal team, I want to thank you, dear Judicial Watch supporter. If you're supporting this work, you've helped us get to the Supreme Court not once but twice on a key election law issue. We've won one of the cases already. Next one comes up next month, and then the court will decide, presumably by the end of the term, and probably by the end of June or so. And we are only able to do this great work with the support of Judicial Watch members such as those, and you know who you are if you're supporting us. And I encourage you, if you're not, this is the sort of work we're doing, And we can't do it without the generous financial support, voluntary. We don't get tax dollars to do the work, Lord knows, of patriotic Americans. And so go to judicialwatch.org and also read this brief. Get the brief out there. Have other people read it. It's just great history. And go back and look at the Voss decision that we won. You're going to be thrilled about that as well. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.